apprise this court that the filing of the charge sheet will not come in the way of granting a stay order.
Pardon? You argue your whole petition appeal. Argue it. We'll decide the whole appeal.
Decide the whole appeal.
You will argue on the appeal, na? We'll leave that question open. We will hear him on that maintainability aspect also, and we will decide it.
My lord, for that I will have to place on record a memo of citation, my lord.
Give.
Milords, my one submission, Milords.
Yes.
If I'm allowed to argue on maintainability first, Milords, then we can go out on the merits.
Okay, very well. Maintainability.
Because the office has rightly raised an objection.
We'll argue on maintainability what is being contended, so that he can also hear it now, because he was not there when we left that question. We should notice keeping the maintainability open. So you will argue maintainability so that he can also reply. Okay?
Okay, my lord. That FIR or charge sheet can be quashed either under section 482 of the CRPC or under article 226 of the Constitution.
Okay.
So it is a long-standing position of the Supreme Court since state of Haryana versus Bhajanlal, where they are given 7 illustrative cases in which the Honorable Supreme Court may choose to exercise its powers either under section 482 CRPC or under article 226 of the Constitution of India. Now, in the given situation, the district has raised an objection that the learned single judges exercise the power under section 482. And I had clearly brought it to the notice of this court that section 482 is a territorial power which is applicable only to subordinate courts. It cannot be extended beyond the territorial jurisdiction of any high court. If any power is to be exercised beyond the territorial jurisdiction, it has to be necessarily exercised under article 226(2) of the Constitution itself. It cannot be exercised within section 482. And in this regard, I just want to read
So
one para from this.
482 only confines to the litigation within the state.
Within the state, my lord. And this is state of Punjab, the Dwinder Pal Singh Bhullar. It is Supreme Court judgment of 2011, in which the Honorable Supreme Court has compared and contrasted section 482 vis-a-vis article 226. That what is the ambit and scope of these two section and article?
Just
they are to be compared and contrasted.
Take it, please.
Copy दीजिए. Copy दीजिए.
Copy I am not having.
You have to get the copy now if you are relying on the previous date also I told you to give it.
But here in this judgment, page number 18 of this judgment. Page number 19, para 40. So, my lord, I would like to read these two paras, rather these 3 paras. But I will first begin with para 2 on page number 19.
To which paras you will be relying upon? To
Last 2 paras of the para 40. Last 2 paras of the section 40 on page number.
So you are
19.
relying upon only para 40.
Yeah, para 40. So these 2 paras, I would just
Yes, read it.
read it. Application under section 482 Code of the Criminal Procedure lies before the High Court against an order passed by the court subordinate to it in a pending case bar proceedings. Generally, such powers are used for quashing criminal proceedings in appropriate cases. Such an application does not lie to initiate criminal proceedings or set the criminal law in motion. Inherent jurisdiction can be exercised if the order of the subordinate court results in the abuse of the process of the court and are calls for interference to secure the ends of justice. The use of the word process implies that the proceedings are pending before the subordinate court. Again and again, the use of this expression subordinate court. When reference is made to the phrase to secure the ends of justice, it is in fact in relation to the order passed by the subordinate court, and it cannot be understood in a general connotation of the phrase. More so, while entertaining such application, the proceedings should be pending in the subordinate court. In case it attained finality, the inherent powers cannot be exercised. Party aggrieved may approach the appellate bar revisional forum. Inherent jurisdiction can be exercised if injustice done to a party Example, a clear mandatory provision of the law is overlooked or where different accused in the same case are being treated differently by the subordinate court. An inherent power is not an omnibus for opening a Pandora box, that too for issues that are foreign to the main context. The invoking of the power has to be for a purpose that is connected to a proceeding and not for sprouting an altogether new issue. Now, my lord, now here he is contrasting it with the power under Article 226. A power cannot exceed its own authority beyond its own creation. It is not that a person is remediless. On the contrary, the constitutional remedy of writs are available. Here, the High Court enjoys wide power of prerogative writs as compared to that under Section 482 Code of the Criminal Procedure. To secure the corpus of an individual, remedy by way of habeas corpus is available. For that, the High Court should not resort to inherent power under Section 482 Code of the Criminal Procedure, as the legislature has conferred separate powers for the same. Needless to mention that Section 97 Code of the Criminal Procedure empowers the magistrate to order the such a person wrongfully confined. It is something that the same court exercising authority can, in relation to the same subject matter, invoke its writ jurisdiction as well. So, my lord, here it's clearly stated that the High Court enjoys wide power of prerogative writs as compared to that under Section 482 Code of the Criminal Procedure. And clearly stated in the preceding para that Section 482 applies only and only to the subordinate courts. And then I want to immediately go to the preceding para's first line. To inhere means that it forms a necessary part and belongs as an attribute in the nature of things. The High Court under Section 482 Code of Criminal Procedure is crowned with the statutory power to exercise control over the administration of justice in criminal proceedings within its territorial jurisdiction.
Where are you reading?
The High Court under Section 482 Code of Criminal Procedure is crowned with the statutory power to exercise control over the administration of justice in criminal proceedings within its territorial jurisdiction. My lord, this is page number 18. Page number 18. This second last para on page 18. My lord, last para on page 18.
You must read in Syria term. Come from 40.
From the beginning.
Obviously, read from 40. We have to read in context.
Okay, full para.
Obviously.
Okay. It is evident from the above that inherent powers can be exercised only to prevent the abuse of process of the court and to secure the ends of justice. However, powers can be used provided there is no prohibition for passing such an order under the provision of the Code of Criminal Procedure, and there is no provision under which the party can seek redressal of its grievance. Under the garb of exercising inherent powers, the criminal court cannot review its judgment. Such powers are analogous to the provision of Section 151 Code of Civil Procedure and can be exercised only to do real and substantial justice. The rule of inherent powers has its source in the maxim Quadolex aliqui considere videtur id sino quo ipsa s upon potest, which means that when the law gives anything to anyone, it gives also all those things without which the thing itself could not exist. The order cannot be passed by bypassing the procedure prescribed by law. The court, in exercise of its powers under Section 482 Code of Criminal Procedure, cannot direct a particular agency to investigate the matter or to investigate the case from a particular angle by a procedure not prescribed in Code of Criminal Procedure. Such powers should be exercised very sparingly to prevent abuse of process in any court. Court must be careful to see that its decision in exercise of this power is based on sound principle. To inhere means that it forms a necessary part and belongs as an attribute in the nature of things. The High Court under Section 482 Code of Criminal Procedure is crowned with a statutory power to exercise control over the administration of justice in criminal proceedings within its territorial jurisdiction. Only within its territorial jurisdiction. This is to ensure that proceedings undertaken under the Code of Criminal Procedure are executed to secure the ends of justice. For this, the legislature has empowered the High Court with an inherent authority which is repository under the statute. The legislature therefore clearly intended the exercise of such power in the High Court to control proceedings initiated under the Code of Criminal Procedure. Conferment of such inherent power might be necessary to prevent the miscarriage of justice and to prevent any form of injustice. However, it is to be understood that it is neither divine nor limitless. It is not to generate unnecessary indulgence. The power is to protect the system of justice from being polluted during the administration of justice under the court. The High Court can intervene where it finds the abuse of the process of any court, which means that wherever an attempt to secure something by abusing the process is located, the same can be rectified by invoking such power. There has to be a nexus and a direct correlation to any existing proceeding, not foreclosed by any other form under the code to the subject matter for which such power is to be exercised. Application under Section 482 Code of Criminal Procedure lies before the High Court against an order passed by the court subordinate to it in a pending case proceeding. Well, 7 times subordinate code expression has been used in this para. Generally, such powers are used for quashing criminal proceedings in appropriate cases. Such an application does not lie to initiate criminal proceedings or set the criminal law in motion. Inherent jurisdiction can be exercised if the order of the subordinate court results in the abuse of the process of the court and or calls for interference to secure the ends of justice. The use of the word process implies that the proceedings are pending before the subordinate court. When reference is made to the phrase to secure the ends of justice, it is in fact in relation to the order passed by the subordinate court, and it cannot be understood in the general connotation of the phrase. More so, while entering such application, the proceedings should be pending in the subordinate court. In case it attained finality, the inherent powers cannot be exercised. Party agreed may approach the appellate regional forum. Inherent jurisdiction can be exercised if the injustice done to a party, example, a clear mandatory provision in the law is overlooked, or where a different accused in the same case are being treated differently with a subordinate court. An inherent power is not an omnibus for opening a Pandora box, that too for issues that are foreign to the main context. The invoking of the power has to be for the purpose that is connected to a proceeding and not for sprouting an altogether new issue.
Which judgment others?
So, my lord, this is what the law. And what Honorable Supreme Court has stated in this judgment, similar observations have been made by High Court of Kerala Division Bench in Krishna Kumar Menon versus Neotrix. So, my lord, just kindly I will advert the attention of the court towards
Which page?
1 minute. Lord, page number 55, my lord.
Yes.
Page number 55, para 6. The question to be considered in this case is not the power of the High Court under Article 226, but jurisdiction under Section 482 CRPC. Section 482 CRPC reads as follows: saving of the inherent powers of High Court. Nothing in this court shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary to give effect to any order under this court, or to prevent abuse of the process of any court, or otherwise to secure the ends of justice. For the purpose of Criminal Procedure Code, High Court is defined under Section 2E of the CRPC as follows. High Court means in relation to any state, the High Court for that state. In relation to a union territory to which the jurisdiction of the High Court for a state has been extended by law, that High Court. In relation to any union territory, the highest court or the criminal appeal for that territory other than the Supreme Court of India. Therefore, High Court mentioned in Section 482 of the CRPC shows only its relation to the state. Hence, under Section 482 CRPC, High Court can quash only complaints filed in the state. This court's powers, control and supervision, both judicial and administrative, are limited to courts in Kerala. For this proposition, we get support from the decision of this court in Chelappan versus Chandulal and Srithara Kamath versus Jwala Gupta. Article 366(14) of the Constitution of India defined High Court as follows. High Court means any court which is deemed for the purpose of this Constitution to be a High Court for any state.
Come to the next para.
Here, territorial jurisdiction the High Court establishes clear. A pending matter in a court under the jurisdiction of another High Court cannot be quashed by the Kerala High Court by using inherent powers provided under Section 482 CRPC. Similar is the power under Section 227 of the Constitution of India. Article 227(1) of the Constitution of India reads as follows. Every High Court shall have superintendence over all courts and tribunals throughout the territories in relation to which it exercises jurisdiction. Matter may be different. Now, my lord, now he is telling matter may be different if the petition under Article 226 is concerned, where part of the cause of action arose in the state where the High Court is having jurisdiction. The jurisdiction of the High Court under Article 226 and 227 are separate and independent. A similar provision as contained in Article 226(2) is absent in Section 482 or Article 227. Article 2262 reads as follows. The power conferred by Clause 1 to issue directions, orders, or writs to any government authority or person may also be exercised by the High Court exercising jurisdiction in relation to the territory within which the cause of action wholly or in part arises, for the exercise of such power, notwithstanding the seat of such government or authority or the residence of such person is not within those territories. The above clause was inserted by the Constitution 15th Amendment Act 1978. By insertion of this clause, if whole or part of the cause of the action arose in a state, High Court of that state will get the jurisdiction. The position is well explained by the Supreme Court in Ireland Natural Gas Commission, Utpal Kumar Basu. So, my lord, it is abundantly clear that under Section 482, the power cannot be exercised beyond the subordinate court or the territorial limits of the court. The power can be exercised only under Article 226 of the Constitution. And this point has been clarified by Supreme Court in a number of the cases. Only one I will read, my lord. My lord may permit me. Rajendran Naveen Chandra Majithia, my lord, which is the most authoritative case which is cited in this case. So I will just read from which page. One moment, my lord. My lord, page number 79. Para number 30, para number 33 and 34. When the constitution was framed, Article 226 as it originally stood therein provided that every high court shall have power throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases, any government within those territories, directions, order the writs. Some of the decisions rendered by different high court during the earlier years of the post-constitution period have given a wider perspective regarding the jurisdiction of the high court and pointed out that a high court can exercise powers under Article 226 even in respect of tribunals or authorities situated outside the territorial limits of its jurisdiction. If tribunals or authorities situated outside the territorial limits of its jurisdiction, if such tribunals or authorities exercise powers in such a manner as to affect the fundamental rights of the person residing or carrying on business within the jurisdiction of such a high court. So, my lord, now I am moving to the next para. But a constitution bench of this court has held in Election Commission of India versus Saka Venkat Subba Rao. Thus, the power of the High Court to issue writs under Article 226 of the Constitution is subject to twofold limitation, that such writs cannot run beyond the territories subject to its jurisdiction, and the person or authority to whom the High Court is in power to issue writs must be amenable to the jurisdiction of the High Court either by residence or location within the territories subject to its jurisdiction. It was a set decision of the Constitution bench which necessitated the Parliament to bring the 15th Amendment to the Constitution, by which clause 1A was added by Article 226. That clause was subsequently renumbered as clause 2 by the Constitution 42nd Amendment. Now, clause 2 of the Article 226 reads thus: the power conferred by clause 1 to issue directions or order the writs to any government authority or person may also be exercised by any high court exercising jurisdiction in relation to the territories within which the cause of action wholly or in part arises, for the exercise of such power, notwithstanding the seat of such government or authority or the resident of such person is not within those territories. The object of the amendment by inserting clause 2 in article was to supersede the decision of the Supreme Court and Election Commission of the Saka Venkat Subba Rao Supra and to restore the view held by the High Court in the decision cited above. So the power conferred on the High Court under Article 226 could as well be exercised by any High Court exercising jurisdiction in relation to the territories within which the cause of action wholly and in part arises, and it no matter whether the seat of the authority concerned is outside the territorial limit of the jurisdiction of that High Court. The amendment is thus aimed at widening the width of the areas of reaching the writs issued by the different High Court. So, this was the entire background of the history in which Article 226(2) was inserted by conferring the High Courts with the power to exercise extraterritorial power. Now, the question which is being raised is within the ambit and scope of Ramkrishna Fauji versus state of Haryana. Now, they are stating what is being dealt with is the letters patent of the Punjab and Lahore High Court, which are applicable to the Punjab High Court. So, in those letters patent, it is very clearly written that the criminal jurisdiction is excluded. If we read those letters patent, it becomes very obvious that yes, the criminal jurisdiction is excluded in that. But when we come to our High Court of Karnataka Section 4, what we find is that it is a substantial reproduction of the Article 136 of the Constitution. If we use that phrase which has been used, judgment, decree, order, or sentence, the expression sentence has been very expressly used, my lord. The sentence connotes that any punishment, any forfeiture of property, any capital punishment, or anything of that sort, connoting that the criminal jurisdiction is inherently contained in it. So, that judgment in its two parts. Part 1 of the judgment deals that where the power has not been taken away from the High Court expressly by the legislature, the High Court will continue to exercise its writ jurisdiction in exercise of the criminal powers. And the latter part of that, the second part of that judgment deals with the comparison of the letters patent of the Punjab and Haryana High Court with those of the Delhi, Gujarat and Andhra Pradesh. After that discussion, the Honorable Supreme Court has concluded that since in the bracketed portion of these High Court letters patent, this express prohibition regarding the criminal jurisdiction is contained, therefore these courts are prohibited from exercising the criminal jurisdiction. But that prohibition is not contained in the letters patent of Karnataka or Kerala or Chhattisgarh or Madhya Pradesh, because the legislature is having the power to confer that jurisdiction on the High Court. So that aspect has also been dealt with in Ramkrishna Fauji.
Show us. Show us.
Okay, ma'am.
mention
So, my lord, it is on page 199.
Petition is filed under 226 so here written is section 400 तो ये क्या है ना जब उसे जो यूज करते थे और ठीक है उसे जो इसको क्या है ना कुछ लिखे थे साहब the body is rightly 26 to 27 केरला कर्नाटक के जजमेंट इसी तरीके से जबरदस्त जबरदस्त
Yes.
So, my lord, it is on page number 199. So, from here, the discussion has been made.
Yes.
And we do further ordain. So, my lord, this is the class 10 of the letters patent of the Punjab and Lahore High Court, which has been brought out here. On page 199.
Lahore has, Punjab has letter patents.
Pardon, my lord?
Punjab has letter patents.
My lord, this.
Now tell us one thing. Otherwise, your jurisdiction lies with before the Punjab Haryana High Court. Otherwise,
My lord, the entire cause of action has arisen within the territorial jurisdiction of this court. So, by virtue of the Article 226(2), only this court is having the jurisdiction. At no point of time, any cause of action has arisen in Panipat. And the other day, I explained to this court that the judgment of the Rupali Devi does not apply in the given case because the complainant has sent a complaint through post from here itself, and her statement has been recorded under 164 CRPC before a magistrate, where she is clearly admitting that she continues to stay in the bank quarter. There was absolutely no occasion of shifting any time to the parental home. So the advantage of that judgment will not be available to her. So all along she has been staying in Bangalore on the day when this FIR was lodged. And in addition, this FIR is hit by TT Antony with the state of Kerala, which clearly states that only the earliest and the first information in regard to the commission of a cognizant offence will satisfy the requirement of section 124. Therefore, there cannot be a second FIR and no fresh investigation on receipt of every subsequent information in relation to the same cognizant offence or the same occurrence or incident. A police officer in charge is required not only to investigate the same cognizable offence reported, but all other connected offences. So, that is very, and as regard the aspect of investigation, In TT Anthony itself, the Honorable Supreme Court has very clearly stated the sweeping power of the investigation does not warrant subjecting a citizen each time to the fresh investigation. The sweeping power of investigation does not warrant subjecting a citizen each time to fresh investigation in respect of the same incident.
Okay. Anything else? Unko sune, then we can hear them, na?
Okay, ma'am.
Yeah. What is your case on maintainability?
Maintainability, I am relying on three judgments, my lords. One, as my friend has told, Ramkishan Fauji versus State of Haryana, my
What
lords.
is the proposition you are advised?
My submission would be that, my lords, not maintainable, if the relief sought is in nature of criminal jurisdiction, my lords, intra-court appeals are not maintainable, my lords. That is what was held in these two judgments.
His argument is 226 can be in court for quashing of FIR.
That has been answered here, my lords. Here also, it's the same. 226, if it is for civil in nature, I'll read the relevant paragraphs, my lords.
You have that Kim Mansu also.
Yes, please, my lords. There also, the learned single judge had passed the order of Allahabad High Court, which was challenged before the Supreme Court, my lords, not before the division bench of Allahabad High Court. There also, they sought for the quashing of the FIR, which was dismissed by the learned single judge of Allahabad High Court. It came to be challenged before the Supreme Court. So he has relied on this judgment on the basis of the facts,
Okay.
not on the maintainability aspect. My lords.
Let's see, come to that judgment which you are relying upon.
Please, my lords.
This is a latest judgment. This is also
2017, my lords. Thereafter, my lords, based on this judgment, a similar case of facts, my lords, the Guwahati High Court, the division bench of Guwahati High Court has decided on the very aspect, my lords. Once I'll go through the Fauji judgment and then rely on that judgment, my lords. That is at page number 2, my lords, the very beginning. The conception of criminal jurisdiction as used in clause 10 of letters patent is not to be construed in a narrow sense. It encompasses in its governed inception and consequence. It is field in respect of which jurisdiction is exercised is relevant. Contention that solely because is a writ petition is filed to quash an investigation, it would have room for intra-court appeal, and if a petition is filed under inherent jurisdiction under section 482 of CRPC, there would be no space for an intra-court appeal, would create an anomalous, unacceptable and inconceivable situation. The provision contained in letters patent does not allow the permit such an interpretation. When courts are required to consider a bar or non-permissibility, courts have to appreciate same in true letters and spirit. It confers jurisdiction as regards subject to controversy or nature of proceedings, and that subject is exercise of jurisdiction in criminal matters. It has nothing to do whether order has been passed in exercise of extraordinary jurisdiction under Article 226 of Constitution or inherent jurisdiction under Section 482 of CRPC. In case at hand, writ petition was filed under Article 226 of Constitution for quashing of recommendation of Lokayukta. The said recommendation would have led to launching of criminal prosecution. And as factual matrix reveals, FIR was registered and criminal investigation was initiated. The single judge analyzed the report and ultimate recommendation of statutory authority, and though it seemed to quash the same, and after quashing the same, as he found that FIR had been registered, he annulled it, treating the same as natural consequence. Thus, effort of writ petition was to avoid a criminal investigation, and a final order of writ court is quashment of registration of FIR and subsequent investigation. In such a situation, to hold that a single judge in exercise jurisdiction under Article 226 of Constitution has passed an order in civil proceedings, as order was challenged, was that of quashing judicial authority, that is Lokayukta, would be conceptually fallacious. It is because that matters is the nature of proceedings, and that is litmus test. Intra-court appeal against such an order is not maintainable. And it has been the paragraph number 58 at page number 19, my lords. When the court passed this judgment, my lords, it has relied on few judgments. At paragraph number 58, page number 19, the full bench of High Court of Delhi in CS Agarwal versus State and others was dealing with the situation wherein a writ petition was filed before the High Court under Article 226 of the Constitution of India, read with Section 482 of CRPC, seeking for appropriate writ or for quashing of FIR. As a writ petition was dismissed by the learned single judge, an intra-court appeal was preferred. A preliminary objection was taken by the respondent as regard the maintainability of the LPA, contending that the judgment of the learned single judge was passed in exercise of criminal jurisdiction, and a letters patent appeal against such an order is barred by clause 10 and clause 18 of the letters patent constituting the High Court of Jurisdiction at Lahore, which is applicable to the judicator of High Court of Delhi. The full bench analyzed clause 10 of the letters patent and took note of what has been prohibited for the entertaining an intra-court appeal. A full bench analyzing various decisions opined thus: proceedings under Article 226 of the Constitution would be treated as original civil proceedings only when it concerns civil rights. A forfeit of if it concerns a criminal matter, then such proceedings would be original criminal proceedings. Letters patent would lie when the single judge decides the writ petition in proceeding concerning civil rights. On the other hand, if these proceedings are concerned with rights in criminal law domain, then it can be said that the single judge was exercising his criminal jurisdiction while dealing with such a petition filed under Article 226 of the Constitution. After so stating, the full bench referred to the Constitution bench deciding in Ishwari Lal Bhagwan Das and distinguished the full bench decision in Andhra High Court in Gangaram Kandaram, and noted the decision of the division bench of Gujarat High Court in Sanjeev Rajendra Bhai Bhatt, and came to hold as follows: the test thus is whether criminal proceedings are pending or not, and the petition under Article 226 of Constitution is preferred concerning those criminal proceedings which would result in conviction and order of sentence. When viewed from this angle, it is clear that if the FIR is not quashed, it may lead to filing of challan by the investigation agency, framing of charges, and can result in conviction or order of sentence. Writ of this nature filed under Article 226 of the Constitution, seeking quashing of such an FIR, would therefore be criminal proceedings, and while dealing with such proceeding, High Court exercises its criminal jurisdiction. Then later, my lords, paragraph number 65. That is at page number 22, my lords. In the case at hand, the writ petition was filed under Article 226 of the Constitution for quashing the recommendation of the Lokayukta. The said recommendation would have led to launching of criminal prosecution, and as the factual matrix reveals, FIR was registered and criminal investigation was initiated. The learned single judge analyzed the report and ultimate recommendation of the statutory authority and thought it seemly to quash the same, and after quashing the same, he found that FIR has been registered. He annulled the treating the same as natural consequence. Thus, the effort of writ petition was to avoid the criminal investigation, and final order of writ court is quashment of the registration of FIR and the subsequent investigation. In such situation, to hold the learned single judge in exercise of jurisdiction under Article 226 of the Constitution has passed an order in a civil proceedings, as the order was, the challenge was of the quasi-judicial authority, that is the Lokayukta, would be conceptually fallacious. It is because what matter is the nature of proceedings, and that is the litmus test. In view of the aforesaid prismatic reasoning, the irresistible conclusion is that the letter patent appeal was not maintainable before the division bench, and consequently the order passed therein is wholly unsustainable, and accordingly it is set aside. However, the state had been diligently agitating the grievance in a legal forum which it thought had jurisdiction. We grant liberty to the state, assailing the order and a learned single judge in accordance with the law. Thereafter, my lords, after keeping this judgment in view, my lords, at page number 24, the Guwahati High Court, my lords, wherein this judgment was referred, and also the point raised by my friend stating that section 4 of our rules also doesn't state that. However, that has been answered here, my lords. Page number 25. This intra-court writ appeal arises from an order dated so and so passed by the learned single bench of this court in a criminal writ jurisdiction being criminal so and so. The said writ petition filed by the petitioner, appellant herein, appearing in person, seeking quashing of the FIR as well as the charges framed against him by the trial court, was dismissed by the learned single judge by the order dated so and so. On the previous date of hearing, we had instructed the registry to make a report regarding maintainability of the writ appeal. Office note dated so and so indicated that Rule 2, Clause 2 of Chapter 5A of Guwahati High Court rules are silent as to whether the intra-court appeal would lie against an order passed in criminal matter by Honorable Single Judge of this court under Article 226 of the Constitution of India. The Honorable Supreme Court in case of Ram Kishan Fauji was a state of Haryana and others reported in so and so had laid down that letters patent appeal does not lie against an order passed by the single judge of the High Court in exercise of criminal jurisdiction. In the said case, the writ petition filed the writ petition before the learned single judge of the High Court was filed under Article 226 of the Constitution of India, and the division bench entertained the letters patent appeal against the order of the learned single judge. The judgment of the division bench of Punjab and Haryana High Court was reversed by the 3 judges bench of the Honorable Supreme Court, laying down that the letters patent appeal, which is akin to the intra-court writ appeal, would not lie to the division bench against the order passed by the single bench of the High Court in exercise of criminal jurisdiction. Milords, the petitioner had relied for 3 judgments, milords. That was, and however, the paragraph 6, having regard to the discussion made herein above, we are of the firm view that the intra-court writ appeal does not lie against the order or judgment passed by the learned single bench in exercise of criminal writ jurisdiction under Article 226 of the Constitution of India. As the Guwahati High Court rules are silent on this issue, the anomaly shall forthwith be clarified with appropriate insertion in the rules clarifying the position that no intra-court appeal lies against an order or judgment passed by the learned single bench in exercise of criminal writ jurisdiction. As a result, the intra-court appeal preferred by the appellant herein against the judgment dated so and so passed by the learned single judge in writ petition so and so is hereby dismissed for as not being maintainable.
The other judgment
Of the this Honorable High Court, my lords.
where is that?
That's
My lord,
That is-
the conclusions of this judgment, are not at its fag end. The conclusions of this judgment, Ramkrishna Poji, are at para number 46. So, after
come.
para 46, the court is dealing with this particular case by making comparison of the class 10 of the Punjab and Haryana latest pattern of the Punjab and Lahore High Court with those of the chartered high courts by clause 15 of the chartered high courts, and then by comparison with the Delhi High Court, Gujarat High Court and Andhra High Court. While Andhra High Court had supported this contention that whether that in criminal jurisdiction also the intra-court appeal will lie, the Supreme Court has concurred with the findings of the Delhi and Gujarat High Court. However, the general law has been enunciated in para 46, where it's clearly stated that an appeal shall lie from the judgment of a single judge to a division bench of the High Court if it is so permitted within the ambit and sweep of the latest patent. So in our latest patent, which are a substantial replica of the Article 136 of the Constitution, this by use of this expression sentence, the adequate powers have been conferred to entertain an intra-court appeal even in criminal jurisdiction.
We'll come back. Any other judgment?
Judgment of this Honorable High Court, my lords, that is in 2014-15, my lords, that page number 53, wherein paragraph number 11,
Page?
43.
Hmm.
In view of the above discussion, we hold that the petition filed before the learned single judge, notwithstanding its nomenclature as one filed under Article 226 and 227 of the Constitution of India, read with Section 482 CRPC, was actually one filed under Section 482 CRPC. The learned single judge was justified in treating.
This is on this fact. Otherwise, can't be a 482 petition because it is seeking relief beyond the territorial limits. That's the argument. Okay. Yes, ma'am. What do you say?
Nepali judgment.
Pardon?
Nepali judgment.
Where is that?
It is practically there in the single judge order.
What does it say? Which paragraph?
Paragraph, my lord, 10, my lord. Paragraph 16 in page 39 of the judgment, in page 39.
Hmm.
We therefore hold that the courts at the place where the wife takes shelter after leaving or driven away from the matrimonial home on account of acts of cruelty committed by husband or his relative would depend on the factual situation, also have jurisdiction to entertain a complaint alleging commission of offence under 498 of the Penal Code.
Hmm.
On this ground, my lord, the FIR which was registered in Panipat is and the intra-court appeal, my lord, cannot be maintained. The my lord, my friend who was reading, my lord, the first judgment, my lord, this is where it says that, my lord, the conception of criminal jurisdiction as used in clause 10 of letters patent is not to be construed in narrow sense. It encompasses in its government inception of consequence. It is field in respect of which jurisdiction is exercised, is relevant. Contention that solely because a writ petition is filed to quash an investigation, it would have a room for intra-court appeal. And if a petition is filed under inherent jurisdiction under 482 CRPC, there would be no space for intra-court appeal, would create an anomalous, unacceptable and inconceivable situation. My lord, this is what, my lord, if an intra-court appeal is entertained, my lord.
Which para you are reading?
My lord, my learned friend was relying on this judgment, 2017 judgment, my lord. The second page of the judgment. Ramkishan Fauji judgment, my lord. Clearly, my lord, it is why an intra-court appeal should not be entertained.
Hmm.
It says, my lord, it would have room for inter-court appeal, and if a petition is filed under inherent jurisdiction.
Okay, we will reserve it on maintainability. Okay.
My lord, I have submitted a judgment of Ram,
And-
this Kamalia judgment, where this Honorable High Court has entertained the writ appeal. That also I once again intend to bring to the notice of this.
Moreover, my lord, it's a matrimonial dispute. Serious allegations are also made.
My lord, page number 37. Page number 37.
Of your compilation.
Yeah, my lord, my compilation.
We are only reserving for maintainability. Okay.
Okay, madam.
Yes, we have heard.
Page number
37 we have noted. We will
Page
look
number
into it.
37, it is a writ appeal, my lord, which was preferred. The original complaint was filed in Bihar, and under Article 226(2), the single judge had transferred the investigation from there to here. Against that, this writ appeal was preferred, and this writ appeal was entertained and adjudicated also.
Okay. Just say that we have heard the appellants. You both are appellants?
Yeah, appellants.
Appellants in person, counsel for the state as well as respondent number 3. Is 36? No, 37. On the maintainability of the appeal. For the respondent number 1 and 2 and 3. You have for 3. Okay. Orders reserved. Thank you.
Date, my lord, for
We'll
vacation.
give you, it will come in the list, Mr. Chadda. It will come in the list. Whenever we will pronounce it, we will give it in list. You have to just watch.
My lord, stay, interim stay may kindly be granted, my lord.
When is the date now?
Sir, July, 22nd July.
Huh?
22nd July.
July, na?
Yes.
Yes. We have time. Okay. Thank you.
ಎಂಟರ್ಟೈನ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ ಇದು ಡಿಸ್ಮಿಸ್ ಆಗೋದಿಲ್ಲ
ಇಲ್ಲೇ ಬರುತ್ತೆ ಓದಿ ಹೇಳಿದ್ರೆ